Hi, and welcome to this latest immigration law update video. In this video, I wanted to look some more at the financial requirement, the minimum income requirement under Appendix FM in relation to family applications. So we've seen the minimum income requirement go up to 29,000 on the 11th of April. And in this video, I'm going to go through the Home Office guidance, which was updated on the 11th of April. It's version 10, and we're going to go through some key aspects in relation to the financial requirement. I will put the link to this guidance in the description to the video, so you can extract from it, and then you might want to cite that when you're making your applications and put that in your representations. We'll also see within this guidance, the Home Office have created some helpful images. So if you're a solicitor or a legal rep watching this, you may want to take those images and you can post those on your firm's social media or your website so your clients are aware as to the provisions in respect of the financial requirement and what financial requirement applies to them. So you will see this guidance is to be used for all applications decided on or after the 11th of April. And you'll see in terms of the changes, the first bullet point is to reflect the increase to the minimum income requirement that was laid before Parliament in the Statement of Changes to the Immigration Rules HC 590 on the 15th of March, which comes into force on the 11th of April 2024. And there's a long narrative introduction. I can scroll through that until we get to the recent changes. So here we are. On the 11th of April 2024, the minimum income threshold increased for new applicants under Appendix FM from the original 18,600 to 29,000. Now, the plan of the government is to bring the increase to the MIR in 3 incremental stages, ultimately reaching 38,700, which is in line with the minimum general salary threshold for skilled workers. Now, the plan is to do that by early 2025. So the initial increase is to 29,000, and there is a planned subsequent increase to 34,500. Now, I'm recording this on the 5th of June 2024. So we're less than a month out until the general election. I wonder if we see a change in government, whether we'll actually see the second and third increments in the increase to the minimum income requirement. I don't know, but I wonder if we will see those. I don't think there'll be any rowing back from the 29,000. I think we're stuck with that. This is important. Transitional arrangements have been introduced for all those already within the routes. Those who applied before the 11th of April 2024 will have their applications assessed against the threshold in place before that date. And look at this, because there's a policy in place in relation to this, unless that will disadvantage them in comparison to new entrants to the routes, when the new minimum income requirement must instead be met. And I'll clarify what's meant by that as we go through the policy. Applications made after the 11th of April will no longer have the separate child component to the minimum income requirement. The minimum income threshold is fixed regardless of the number of children within the family. There are transitional arrangements in place for those with children who are applying for further leave to remain to avoid the transitional arrangements being disadvantageous in comparison to the new flat rate. So new entrants are going to be under a flat rate. There is transitional arrangements for those on the old financial requirement. I'm going to see that's going to be capped at 29,000, regardless of how many children you have. I'm not in this video going to look through the financial requirement for the armed forces, but you'll see there's a rise from 18,600 to 23,496. If you're doing an HM armed forces case, do have a look at the specific provisions within the immigration rules and this guidance. So who needs to meet The financial requirement, those applying family life as a parent, a partner, or as a child of a person with limited leave as a partner. But notice, and I think it's worth re-emphasizing this, that where the sponsor is in receipt of one or more of the following benefits, and you'll see on my screen the benefits that are listed, they have to meet the adequacy of maintenance test. So that's the benefit level, as opposed to the new higher threshold. So before we rush in and think about the new financial requirement, just take a step back and see if your clients would qualify to meet the adequacy test because of certain benefits they receive. So that's important. Let's look at calculating the minimum income requirement. So the summary bullet points are helpful. Those who apply on or after the 11th of April, who are new to the route, have to meet the £29,000 threshold. Those who apply on or after the 11th of April, who are already within the 5-year partner, fiance, or proposed civil partner routes and are applying for permission to stay with the same partner for which they were last granted permission, benefit from the transitional arrangements. They must meet the lower threshold of 18,600 plus the child component, and the child component is capped at 29,000. Now, the third bullet point might confuse people. Let me explain what that is. Those who apply before the 11th of April 2024 must meet the previous threshold of 18,600 plus the child component. There is no cap for this threshold. So for the legal advisors watching this video, you'll know who this is in relation to. So all those applications you quickly made before the 11th of April to avoid the increase, they're assessed under the old rules, and there is no cap in respect of the child element for them. However, once they're granted and come to extend the transitional provisions, and bullet point 2 will apply to them, and they will be capped. They'll be on the 18,600 plus any child component, capped at the maximum of 29,000. Final bullet point: a child applying under Appendix FM must meet the same threshold as the parent they're applying to accompany or join, regardless of the date of the child's application. Now, here's one of the tables I referred to. So if you follow me on social media, you'll see I've posted these tables. I've created a photo of them and I've posted them on my LinkedIn, on my Telegram channel. And I'd encourage you, if you're a representative, a lawyer, you might want to post these to your clients, use these so they can look at the table and see which financial requirement applies to them. And remember that you need, if you're applying to extend, it needs to be with the same partner. If you change partners, you can't rely on the transitional provisions. So there you have it. There's the section within the guidance about those applying for leave to remain with a new partner. They can't rely on the transitional. You would then end up on the 29,000. Here is then the transitional financial requirements. And again, those 4 bullet points summarize it. So to benefit from the transitional financial requirements, you've got to have permission on the 5-year route. And it does cover fiancés. You must have made your first application before the 11th of April 2024. That must have been granted, and you must be now applying for permission to stay with the same partner. This is important. If you're on the 10-year route and you're now trying to switch into the 5-year route, you won't be able to benefit from the transitional provisions. So table 2 sets out the threshold in relation to those on the transitional requirement and the children. And you'll see once you've got 4 children, it's then capped at 29,000. Remember, it's the old provision: first child 3,800, subsequent children 2,400, but capped at 29,000. Obviously, certain children do not attract the additional child component, and that is listed there in the guidance. In terms of children applying at any date, a child applying under Appendix FM must meet the same financial requirement as the parent they're applying to accompany or join, regardless of the date of the child's application. Where the parent is exempt from meeting the minimum income requirement, the child is also exempt. Where it's a new application after the 11th of April, 29,000 threshold, where the parent benefits from the transitional arrangements, the child will also benefit and must be assessed against the lower threshold of 18,600 plus the capped child component. Now, an application submitted before the 11th of April 2024. So for the legal representatives watching, those are all those applications you rush to get in before the change. There is no cap in respect of them. But there is that policy I referred to at the start that if you would only be refused because you're unable to meet the threshold financially and you have 4 or more children and you would meet 29,000, the case should be referred to the family policy team. So there was no cap on the applications made before the 11th of April because they were under the old rules, but there now is a policy where perhaps they had a number of children, which 4 or more, which means the financial requirement would have been over 29,000. They can't meet that, but they can meet 29,000. And you'll see table 3 sets out in respect of the different number of children. So as you'll see, 4 and 5 is over 29,000. So there was no cap for those who applied before the 11th of April, but there is now a policy in place. And again, you'll see which children do not apply in relation to that. Then you have a section in relation to the guidance to the operating principles in meeting the financial requirement. I'm not going to go through those. 2 quick things to finish off with. Savings. The formula to calculate the amount of savings required, if you need to rely on savings, remains the same. It's savings above 16,000, and you need to times the shortfall by 2.5 to represent the 2.5 years of the visa. So it's, if you don't earn anything, it would be 2.5 times 29,000 plus 16,000, which would equal 88,500. The Home Office, in their examples, their maths is a bit confusing and they do it a slight different way. I think the more simple way, and it's the way I've explained it on the webinars I've done, is to adopt that simple formula of 16,000 plus 2.5 times the shortfall. But they've done their own savings to set out their own table to set out how much of the savings you can use. So you can have a look at the different tables and their different formulas they use, and table 4 and table 5 in relation to table 5 is where you're at the 29,000. So the maximum amount would be 88,500. Obviously, table 4 is in relation to those under the transitionals and 18,600. And the maximum being 62,500. But just, it's a bit confusing, the guidance in relation to savings, and I would adopt the formula that I've just gone through. Don't forget, you may now need to rely on exceptional circumstances where the decision would breach Article 8 and have unjustifiably harsh consequences. Over recent years, perhaps with 5-year partner route applications, we haven't had to rely on it in terms because most people have met the financial requirement of 18,600. There are going to be far more people now who do not meet the higher financial threshold. So don't forget to make detailed representations in terms of Article 8, going through the lens of Gen 3.1, 3.2 in terms of alternative sources of financial support, so third-party support, Gen 3.3 in relation to the welfare of children. So there's the guidance there on exceptional circumstances. So I hope that's helpful to you do go through this guidance and use it as you make your representations. Do share those tables the Home Office have provided in the guidance. And I hope that helps you in your applications under Appendix FM and the new financial requirement.